Welcome back to the RG Limited boardroom. Darlings, adjust your pearls and tell the chauffeur to wait because we are dissecting a case that is the ultimate warning for every CEO who thinks a financial crisis is a license to ignore the law. We are looking at the final judgment in Doreen Tarimo and CITCC Tanzania Limited case. This isn't just a labor dispute. It's a lesson in why being right about the money doesn't mean you're right in the courtroom. Here is the High Society briefing on the 24-hour execution, served with fresh wit and the hard truths of Tanzanian labor law, by yours truly, Oksana Ryabets. The scene: a 2.2 billion shilling bloodbath. CITCC, China International Telecommunications Construction Corporation, was in a tailspin. Their audited financial statements were in horror show actually. A loss of Tanzania shillings 1.3 billion in 2021, deepening into a staggering Tanzania shillings 2.2 billion by 2022. The independent auditors even dropped the going concern bomb, warning that the company might not survive. In this boardroom, we know that that's a clear signal to trim the sails when this happens. But CITCC didn't just trim, they hacked. Their move, the invisible agreement. Doreen tried to claim she's been there since 2007 based on an oral agreement. But the company had a written contract from 2012 that explicitly said it, quote, supersedes and replaces, end of quote, everything else. Court lesson number 1. In our world, ink beats air every time. The judge ruled that an oral agreement cannot override a written contract. If you didn't put it in the document, it doesn't exist. This scandal, the 24-hour trap. This is where the company committed a procedural suicide. They summoned Doreen on May 16, 2022, told her she was being retrenched. And when she didn't like their offer, they handed her the pink slip the very next day, May 17th. Darlings, the law doesn't do, quote, express exits. Under Section 39, retrenchment requires consultation, disclosure, and a notice period. If you don't reach an agreement, you must go to mediation, and if that fails, arbitration. So, CITCC ignored the entire queue and jumped straight to the termination. The judge called it a, quote, serious illegality. The pleading paradox. Don't ask, don't get. The lower court, CMA, had originally tried to be nice and awarded Doreen Tanzania shillings 157,667 shillings for a salary increment. But the High Court snatched it back. Why? Because Doreen never asked for it in her original CMA Form 1. Let's look at the court lesson number 2. You are bound by your pleadings. If you don't pray, quote, for it in your initial filing, the judge cannot play Santa Claus and give it to you later. So my final takeaway here. Doreen walked away with a 6-month salary as compensation. Specifically, as we can see from the court files here, Tanzania shillings 4,905,222 shillings, because the company was too impatient to follow the, quote, code of good practice. The lesson. If your bank account is bleeding billions, the court expects you to follow the rules of the exit. In the RG Limited boardroom, we don't do a 24-hour retrenchment. We follow the procedure to the letter, or we pay the price in the High Court. Now, if you'll excuse me, I need to check out my own, quote, supersedes clause. I have no interest in being bitten by, quote, snake without teeth. Doreen Tarimo. Cheers.